Welcome to Chem 327, Experimental Physical Chemistry. Today we will talk about intellectual property, also known as IP, and specifically about patents. Now, it's likely that most of you have not heard much about IP before this lecture, but in this class you're all techies, scientists, engineers. It is important that you get at least a basic understanding of IP. Perhaps because you've heard the term knowledge economy, the use of knowledge to create goods, services, products, that boosts the economy. Well, IP is an essential underlying component of the knowledge economy. Let's start with the definition. IP refers to a creation of the mind, giving it a status similar to that of a real property. For example, you look at your cell phone, you can sell it, you can trade it, and you can get paid. Well, creations of the mind are intangible assets, unlike your cell phone, which is tangible. But the concept of IP is about giving it recognition to be on par with real property, in that they can be sold, they can be traded, you can get paid. Interestingly, this concept is not new. The concept of IP has been around for hundreds of years. And you can look at a little history, even just at the level of Wikipedia article on IP, because it's fascinating that there is a recognition by governments of the importance of these creations of the mind. Now that we talk about being recognized by government, which government? Yes, there are differences between IP rules of different countries, and so much depends on which country you intend to use your IP in. But from a practical perspective, we here have a big neighbor to the south that has a strong influence on us and a market that's 10 times bigger. So, in most instances, even while we have our own Canadian Intellectual Property Office, we look at and give strong consideration to the US IP rules. Well, for now, let's talk about the different forms of IP. What do you do to protect them? If you come up with a wonderful creation of the mind, what can you do about it? Well, perhaps the simplest thing to do is just don't tell anyone about it. You can use your creation, but keep the secret sauce. This is called a trade secret, and we will get back to it later. Another form of IP that you may be familiar with is called a copyright. You see this a lot in the front page of thesis or books, like the little C with a circle around it. The person who created the work owns the copyright to the work as is, unless they transfer it to someone else. So you're not allowed to copy something exactly. That would be a violation of copyright. The most famous example, perhaps, is the song Happy Birthday to You. Until recently, if you try to celebrate a birthday lunch at a restaurant like Eastside Mario's, they find ways to greet you with their own songs, but they do not sing that happy birthday song. Because if they did, they will have to pay royalty to the purported owner of the copyright. But in 2016, a ruling came down that the claim was invalid and that the song Happy Birthday to You is now in the public domain. So you can sing it, you can hear it sang in many places, in restaurants. If you want to read more about the subject, I provided a link to an article about it. And still related to copyright, just a reminder, my presentations, course notes, and quizzes, I own the copyright to these. If you want to copy them, you need my written consent. Otherwise, you'll be infringing on my copyright, my IP. And if you want to read more, you can look at the course syllabus section on institutional policies and support. So let's go on further. Trademarks is something you encounter a lot in your daily life. These are company names, logos, slogans. You can even trademark your own name if it makes sense to you. Sometimes they are designated by a capital T, capital M, which indicates there's a claim for a trademark, or an R with a circle around it, which indicates that it's registered in the country for trademark protection. Industrial design protection is about specific looks and shapes. Well, this is quite important. It's not something scientists typically engage in, so we won't discuss them further. We will spend more time on patents, which is perhaps the most applicable IP protection for you to know about. So first, let me give you a list of websites that are useful. They're what you can search for patents, and they contain a lot of information about patents and trademarks, what they are, how to file them. They have some stories in the sites. At the very least, you should look at the site uspto.gov. That's the US Patent and Trademarks Office, because in most respects, the US is the most important market for many businesses, and that's typically where people like to file their patents. But in addition to that, the website has excellent searchable databases and a lot of information and stories. Now, note that in this sites, not all the entries are awarded as patents yet. Some are just applications, they haven't been issued yet. But what is a patent? A patent is a right given to you, the inventor, by the government that allows you to prevent others from using your invention without your permission. You have to fully disclose the invention in a way that others can replicate it. In exchange for that disclosure, you're again granted exclusivity for 20 years in most countries, which means you can prevent others from using your invention. It's granted by the government, so the details may change a little bit from depending on the country. This disclosure in exchange for exclusivity is sometimes called the patent bargain. When you were taught to search for scientific literature, you likely didn't hear much about the patent literature. Perhaps it's because they're not peer reviewed in the same way as papers are. Rather, patents are subject to examination by a patent examiner. But note that to apply for a patent, as was said earlier, you have to fully disclose the details of the invention in such a way that it can be replicated. So, as a researcher, if you're working on a particular process or material or a device that is patented, it may be quite useful for you to look at the patent literature because it is likely more complete in describing the details than a peer reviewed paper. Because there are strong consequences. If if the claims on the patent cannot be replicated, that may be grounds for invalidating it. So even if you're not thinking of filing a patent yourself, it may be useful for you to get familiar with the sites that I've given before, particularly with the uspto.gov site. But if you're interested in acquiring a patent, what can be patented? Well, there are only three criteria. It has to be something novel, non-obvious, and useful. That doesn't sound too hard, does it? You just have to be able to convince the patent examiner that your invention satisfies these three requirements. And that may take some time and some give and take. Let's take a look at some examples of patents. One of the most well-known and lucrative patent is the basis of a product that you've all used. This here is the original patent written by Alexander Graham Bell for the telephone in 1876. You should look it up. It's short and simple. Here's another example. It has a very low-key title of three electrode circuits element utilizing semiconductive materials. If you look at it closely, the drawings may look familiarly similar to the notebook that I showed you in the lecture on record keeping. Yes, this is the patent by Bardeen and Brattain about the transistor, the foundation of all of modern-day electronics. Let's look at something a bit more recent. And I want to show you the common format of a US patent. You see on the top the patent number. If you're searching for a patent, that's the number to search for. And it shows you the date of filing. Remember that you get 20 years exclusivity from the date of filing. There's a title, and you look at the inventor, an assignee, who the patent is assigned to. And just like a paper, there's an abstract, there's background information, there's figures, then there's experimental details. And lastly, the most important part from the point of view of ownership are the claims. What is being protected in the patent? Here are the claims for this patent. It starts with what is claimed is, and I've shown you here 4 claims of the total 29 in this patent. Now, can you guess what's the importance of this patent? Let's look at it again. Yes, this is the patent based on the thesis of Larry Page, the one that led to the unique search algorithm and the successful company we now know as Google. Now, I don't want you to think that patents are only about scientific breakthroughs. That was not in the criteria at all. Novel, non obvious, and useful are all that's needed. So let's look at this patent. The title is Spatial Logical Toy. Note the name of the inventor. Yes, this is the patent for Rubik's Cube. And yes, toys can be patented. I also don't want to leave you with the impression that all patents lead to hugely successful products. In fact, most patents do not lead to anything, unfortunately. Perhaps because it takes a lot more resources to go from patent to product, and perhaps sometimes there's just no need for them. IP protection, while important, is just the first step in the commercialization process, which we will not discuss here, but if you're interested, come and talk to me about it. Here are examples of products that satisfy the novel, non-obvious, useful criteria for patent, and they have been issued patents. You may have fun looking them up. And in fact, there's a lot of websites that show you some of the funniest things ever patented. So maybe now that you're interested in being able to have a patent, let's look at the pros and cons. If you have a patent, you will have exclusive control of the content. And it's good for society in general because if you invent something and keep it a secret, the secret dies with you. Somebody else would then have to rediscover and reinvent it. As you know, in science and technology particularly, we make progress by building on what was done by those who came before us. By encouraging disclosure of knowledge, others can build upon them and make further inventions. Now, in return, to encourage this disclosure, because it is good for society, the original inventor gets 20 years of exclusive rights to the invention, or to license or sell it for compensation. What about negative sides? Well, first of all, it costs a lot, and it's per country, which quickly multiplies the costs. The initial filing fee may not be bad. In Canada, it's about $200 to $400. But if you need expert advice, it can cost a fortune since patent agents and lawyers will charge you upwards of $400 per hour, and it will take many hours to write the patent. It will then be examined by a patent examiner who will, more likely reject it first, just like a paper. The first referee's report tends to be negative. You'd have to then answer, probably again working with a patent expert, and each back and forth costs. Now, once it's approved, you need to pay maintenance fees. If you want protection in other countries, you have to pay to each country. And you may even have to pay for translation to the local language. And then if you have a patent and somebody infringes, well, there's the issue of enforcement. The patent gives you exclusivity. It gives you the right to enforce. The government does not do enforcement for you. That means if someone infringes, uses your patent without your approval, it's up to you to sue them for compensation. Again, more lawyers and more costs that are non-trivial. So if you've heard of complaints from some on why universities are not filing enough patents, I think those people who argue that have no clue about the costs involved, not just in filing, but also in enforcing patents. From the point of view of a business, another negative side of a patent is that it means that you have to disclose everything about your invention. That could give others a clue on how to develop a competing product. And sometimes that's not good for you. So you have to weigh carefully the pros and cons of filing a patent. If you built an instrument that can be reverse engineered easily, maybe you really need to patent. But if you're making a coating that has many components that are hard to identify, well, perhaps you don't want to do so. Crafting a patent, how it is written and what is claimed, and strategizing about IP in general is quite interesting work for the right personality. There's a lot of aspects about IP strategy that's appealing to a technical mind, and a technical background is an excellent one for becoming a patent agent or a patent lawyer. I know a number of our former students who have gone into this line of work. Now, here's a few other considerations and whether or not you can patent. Inventorship is a well defined concept, and the correct inventors must be named in the patent. And the invention must not have been disclosed publicly prior to applying for a patent. In the US and Canada, it cannot have been disclosed more than a year prior to filing. There's a 1 year leeway. But what does it mean to disclose publicly? That includes talking about it to others publicly. Papers, posters, seminars, for example. Those are public disclosure. But what about talking to a small group? Well, that's debatable depending on the group. When you work for a company, they're likely to ask you to sign a non disclosure agreement so you do not talk about what you're working to others, to your friends, to your family. Similarly, you may ask people to sign such a non disclosure or confidentiality agreement before you talk to them about your special secret sauce. But in general, I'd advise you to learn to talk without disclosing your secret sauce if you intend to patent. Note that if you sell your product, for example, your secret sauce, that would constitute public disclosure. So, you have to think of why you would want to patent your invention by considering why you need that patent. Unless you're independently wealthy who just wants the vanity of holding a patent in your name, they give you a nice little certificate for your patent. You have to think of what your patent will provide for you. Typically, it's meant as a tool to help you build your business. We won't go into that, but anyone interested in this aspect, building a business, talk to me since I've worked with many students in building science-based startups. But supposing you have an invention that you want to commercialize and you don't have the money to spend on patents, what can you do? Okay, let's get back to keeping it a secret. A trade secret can refer to anything that can give you an advantage. It includes your procedure, your design, your composition, your plans, but it also can include your customers and many other things. And really, trade secret is nothing more than keeping it a secret by any means that you can. Trade secrets are common in everyday products. You look around your house, you see WD-40, Mrs. Fields cookies, you bought KFC with its combination of herbs and spices. These are protected as trade secrets. But the most famous example that people always mention when they say trade secret is the formula for Coca-Cola that has been a secret for over 100 years. Legend has it that the closely guarded secret was stored in a vault and was known to only 4 people who cannot travel on the same airplane. Well, that's probably an exaggeration. But a dozen years ago, there was an attempt to steal some secrets of Coke and sell it to their rival, Pepsi. You can look it up in these links. They're short read and interesting examples of industrial espionage. It illustrates it illustrates issues about trade secrets. You must try to protect it. If someone steals it, you can sue. But if someone is able to come by it through their own means, then it's okay. They can make even a good effort to figure out the secret. They can reverse engineer it, they can analyze the details. That's allowed. So if they figure out the secret, you can stand to lose if that happens. And so there's this interesting decision point to keep it a secret or to patent. It all depends on what your invention is, what you intend to do with it, what resources you have. You have to weigh the pros and cons. To summarize today's lecture, You've had an introduction to the basics of intellectual property and the different types of IP. I'd like to end the video by asking a question that you can think about. Should you protect your intellectual property, and why? As you may know, there is an ongoing discussion regarding open source. Some people argue that discoveries, particularly those that came about because of public funding, should just be made available openly for free to everyone and not be protected. I encourage you to think about this, to examine the pros and cons of open source, taking into account what you learned today about IP. You can put down your thoughts in the Quercus discussion board and hopefully initiate a discussion among all of you.